Welcome to Doughty Street's Zoom seminar on COVID-19 practice and procedure in the immigration trials and courts. My name's Simon Cox. I'm a barrister at Doughty Street Chambers, and I'm joined for this seminar by Rowena Moffatt and Alasdair Mackenzie, who are my colleagues in the immigration team at Doughty Street. Thank you very much for coming. We're expecting around 100 people to join online today. So for those of you who are new to Zoom and haven't attended a webinar before, you'll notice that your mic is muted and that your screen is switched off. Sorry, that your videos are off. That's a pre-setting, and don't be alarmed, it just stops any background interference. But you will be able to participate in the seminar through the Q&A function. So if you look down towards the bottom of the screen, on your Zoom screen, you'll see there's a tab there, Q&A, and you can go into that box and type in questions that you have for us, and we will be picking those up as we go through the seminar, and we will try and answer them towards the end of the seminar. We're planning on starting with three short presentations. Rowena will start us off by talking about the latest developments in the first tier tribunal, Immigration and Asylum Chamber. Then Alasdair will take us up to the Upper Tribunal, and I will be dealing with the administrative court cases. Obviously, this is a moving target. Lots of changes in the last 2 or 3 weeks. More changes to come probably. So we won't be able to say with any confidence some of the questions you have for us, but we hope that we can share with you what we've learned from our own practices and what we've heard about from other colleagues in Doughty Street Chambers. Is my microphone any better now? I'm seeing that it's not, people are having trouble in hearing me. I hope it is. I'm sorry, that might be a problem with Wi-Fi here. So we're recording this session, so a copy will be available for you or your colleagues if they couldn't attend today's session. Please do post any questions that you have for us about practice and procedure under COVID-19 in the Q&A box at the bottom of the screen. And once the short presentations you're about to hear have finished, then we will pick up on those questions and try and answer them. So first of all, I'd like to turn over to Rowena Moffatt, who's going to take us through the latest developments in the practice and procedure. But before that, just to point out that the screen that you're now seeing, for those of you who haven't seen it, is the HMCTS's webpage, their daily operational summary. It's the best place to go to find out what the current guidance is for each of the tribunals and courts that we're working in. But for now, over to you, Rowena. You're muted, Rowena.
Thank you very much. Great start. I'm going to talk about 2 main points of procedure and practice in the light of COVID-19 in the first tier. So hopefully the slide's going to move on in a minute and it will come up with the amendment to the tribunal procedure rules. That's the first thing I'm going to talk about. And apologies, it's so small. Hopefully you can see it on your screens, but because of Zoom, it's quite difficult to have many slides. So I've just got one holding slide for the presentation. So the first thing I'm going to talk about is the amendment to the tribunal procedure rules, which came into force just before the bank holiday. And the second relates to the notices and directions being sent out of the various hearing centres. As Simon said, it's a moving target. Things seem to be changing all the time. So we'll be really interested to hear about your experiences of what's been happening in the first tier as well. So turning first then to the amendment to the procedure rules. These entered into force on the 9th of April, which is last Thursday, and I put the relevant part of the new SI on the slides. There are 2 amendments for the purposes of COVID-19 in the first tier. The first relates to paper-based decisions. So what the amendment does is insert a new Rule 4A after the main case management powers in Rule 4. And this modifies the current rule, which permits the tribunal to take a decision without a hearing, which is Rule 25. The current Rule 25 does permit the tribunal to take a decision without a hearing and exhaustively lists the circumstances where it may do so. The first one being where the parties consent, and the important one for our purposes being Rule 25(1)(g), which is where the justice requires the justice requires a hearing, a decision without a hearing. And importantly, where the tribunal intends to decide a case on the papers, there's an express requirement to give the parties the opportunity to make written representations. The new Rule 4A, as you see, modifies the previous Rule 25, or the current Rule 25, but it applies notwithstanding what is said there, and provides for the tribunal to make a decision which disposes of proceedings without a hearing and without consent of the parties, if the tribunal considers that 3 conditions are satisfied. And these conditions are cumulative. The first is where a decision is urgent. The second is where a hearing is not reasonably practicable, and hearing there includes a remote hearing, so a hearing conducted either partially or wholly by video or audio. And thirdly, where it's in the interest of justice to do so. So this is quite different from Rule 25 in that, importantly, there is a new insertion that where a hearing by remote means is reasonably practicable, then arguably there should not be a need for a hearing on the papers. And in my view, given that the first tier is already using remote hearings for bail applications, as we know, and has done for quite some time in certain other contexts, arguably a remote hearing would always be reasonably practicable in the first tier. So applying the new Rule 4A, on the face of things, I find it hard to see when the 3 cumulative conditions will be met so as to permit the tribunal to dispose of the need for an oral hearing. That is where the parties don't consent. So there may be some circumstances where, of course, the parties are happy for the decision to be made on the papers. The second main amendment is amending Rule 27 and adding a new Rule 27A. And this provides the first tier with the power to conduct remote hearings in private, if not practicable for that hearing to be broadcasted or accessed by the public. And also provides that hearings conducted in private must be recorded where practicable. In terms of why these amendments are being taken, there's an explanatory memorandum. I put the link on the slides. Obviously, the rule changes are part of the emergency measures taken in response to COVID-19. Specific justification for paper-based hearings is said to be that it will reduce the risk of infection between tribunal users, HMCTF staff, and the judiciary. Now, that's actually quite unclear to me why paper-based hearings, as opposed to remote hearings, would reduce the risk of infection. And Alasdair will speak more on the point of the need for oral hearings to maintain, or in relation to remote hearings, that is. But all that can be said is that the new Rule 4A does seem to make it quite clear that remote hearings will be the norm, and certainly where practicable to do so. So it will all turn, in essence, on the practicability of the technology, and I'll come on to that in due course. Specific justification for the amendment on private hearings simply relates to the tribunal's inability to live stream. So it's a lack of technology, and it just enables hearings to continue, notwithstanding the tribunal not having the proper technology in place. So there's nothing, in my view, massively controversial there, although obviously it's problematic in terms of open justice. In terms of the time limitation, intended to be temporary, but time limit unclear. So Regulation 1.2 says the amendments will expire at the same time as Section 55B of the Coronavirus Act. Section 55 of the Coronavirus Act is subject to the general provisions in the Act, so that's sections 89 and 90 on duration. Section 89 provides for a time limit of 2 years for the Act to remain in force, so also for the regulations to remain in force. But of course, Section 90 allows for both extension of the Act, or for the time limit to be truncated for the Act to expire more quickly. So that's in relation to new procedure rules. In relation to what's being done by the tribunal and the notices that are being sent out, so far the ones I've seen don't take account of the new rule 4A. What the tribunal seems to be doing is sending out notices accompanied by a copy of the directions that are applicable to the online court. So that's a digital pilot that was applicable in Taylor House and Manchester for just a small pool of solicitors. And it's not entirely clear to me how the two documents are intended to interrelate, but it would seem to be fairly clear that the notice should be the primary document, and reliance should be placed on the online directions only insofar as the notice specifically refers to them. So the notices are being sent out by various principal resident judges from the various hearing centres across the country. They're mostly the same, but because of this moving target problem, there were various iterations floating around sent out at different dates. There was confusion about which cases they apply to, whether they apply generally or whether they apply only to the cases they've been sent out in. And it seems clear from what the principal resident judge at Taylor House has said, that they only apply when you've been sent it in a specific case. I'm referring to the most recent one from Taylor House, which is Principal Resident Judge Campbell's directions, and that's dated yesterday. And the main points in that notice, and in most of the ones I've seen, are the following. The first is that all listed hearings are vacated, that is whether they're CMRs or substantive hearings, and all hearings that will take place will be a CMR by telephone or Skype, and will be notified as and when a hearing will be listed. As far as I know, there haven't been any CMRs listed yet, but I could be wrong. All I'm aware of happening is bail hearings, but if you're having CMRs listed, then I'd be interested to know. You're given 5 days to provide telephone numbers and Skype details of all those persons who have any business with the tribunal, so very broad. Obviously that would mean counsel instructed as well as yourselves. Paragraph 4 of the notice is a very important one because it gives a general indication that applications can be made at any time. And this is important because of what will follow, which is the strict deadlines which are given, which will not be applicable in many cases. So it'd be really important for us to make use of paragraph 4 of the notice and to proactively apply for extensions to deadlines under the case management powers of the tribunal and Rule 4, and indeed adjournments where necessary. So this is the problematic paragraph I'm coming on to, which is the requirement to provide witness statements and evidence and an appeal skeleton argument within 15 days of the date of the notice. I've seen some other directions which don't have 15 days, but actually just refer to the pilot timetable, which is even more confusing because that relates to the date on which the appeal is lodged, which doesn't make sense in many cases. But in essence, the problem, or one of the many problems here, is that the directions are sent out in cases which were listed for a CMR. So in cases where, for example, the Home Office was required to take a further decision. And so obviously it's not possible there to prepare the case substantively or to draft an appeal as an argument. Many cases won't be evidentially ready. So again, the ASA can't properly be drafted, can't be complied with. And additionally, the problem of the payment gap with the LAA funding regulations, meaning all work done currently on the skeleton argument and pre-hearing stages will be done at risk. So many problems with this requirement. Paragraph paragraph 6 requires a response from the respondent, from the Secretary of State, from 10 days from the date in which the appeal skeleton argument is sent. And if no response is received within that time limit, it will be assumed that the Secretary of State does not take issue with the submissions contained in the ASA. Now, it's really unclear to me whether that means that the tribunal will simply treat this as a concession. And it's also even more unclear what happens if the Secretary of State sends a holding response, for example, saying, I don't concede, but I'm not able for operational reasons to respond substantively yet. So again, really difficult to know what that means. And I'm sure the Secretary of State would have something to say if it wasn't able for operational reasons to respond substantively to the appeal skeleton argument, and the tribunal then treated it as a concession. So watch this space for that. I think there's many problems involved with that provision of the notice. Paragraph 7 refers to Rule 25 of the procedure rules, which I've already referred to. But this doesn't, the one I've seen doesn't take account of the amendments. So it doesn't take account of the need to satisfy these 3 cumulative conditions before the tribunal is able to decide a case on the papers. And arguably then, it's very unclear how this would fit with the requirement to have a CMR. It's unclear when the written submissions on paper hearings are required, whether they'll be in every case. And indeed, as far as I'm aware, the first tier isn't so far making use of this provision in the notice. It's been the Upper Tribunal which has been doing that. And Alasdair, I know, will be talking more about that. In relation to the online directions that accompany the notice, in the notice that I've seen, the only specific reference to that refers to protection appeals, so not human rights appeals and not EEA appeals. And it would suggest, therefore, that the online directions don't apply more broadly than protection appeals. But again, it's unclear, but I'm trying to work out how the notice and the appeal directions, the online directions, interrelate. But I think given that there's only specific reference in one paragraph of the notice, it should be confined to that one. The last paragraph of the notice I have then requires a list of information to be given to the tribunal about remote hearings. So, for example, the access that witnesses and appellants would have to conduct or to give evidence remotely. And that's obviously problematic because, especially in cases where there's domestic violence or trafficking, some asylum cases, it will be entirely inappropriate to have a person give evidence in an uncontrolled environment. And likewise, even in situations where, for example, someone is in shared asylum seekers, asylum support accommodation, entirely inappropriate, obviously, to give evidence in those circumstances. So that will need to be set out to the tribunal very clearly. One point about bundles, the notice says that there'll need to be an application for anyone who wants to submit more than 50 pages in terms of the bundle size. Well, that seems to me to be entirely unworkable. That any limitation on bundles is not going to be, it's not going to satisfy the requirements of procedural fairness. And I don't think I've ever seen a bundle which is under 50 pages. So I think there's going to be lots of applications there. I'm going to stop there because I know there's a lot more to say and I've already probably gone on too far, but I've already seen one question come in, but please do send in more comments and questions in relation to what's happening in the first tier, because there's a lot that's problematic here.
Thank you, Rowena. Yes, please do send in comments as well as questions. Because of the number of people who are joining, we're now at 105 participants. It's probably not practical to let people speak directly to the whole Zoom chat, but certainly if there's anything that you can share about your own experiences in any of the tribunals or courts that we're dealing with, just type that in as a question in the Q&A at the bottom of your screen, and we'll share it with the rest of the audience. So I'm now going to ask Alasdair Mackenzie to talk about the Upper Tribunal.
Right, hello everybody, I hope you're all well. I'm going to talk about the Upper Tribunal, as Simon has just said. Now, as I'm sure you're aware, almost all the hearings in the Upper Tribunal have been cancelled, although there are one or two remaining in the list. There's a country guidance case listed in June about Sri Lanka, for example, which is still in the list at the moment. So if you do have an important hearing coming up, which you don't want to be adjourned, now is probably the time to suggest to the Upper Tribunal that it ought to stay in the list, because they appear to be trawling through the lists, taking out anything that they think can come out. The tribunal has been issuing some directions about holding fact-finding hearings remotely, that is to say, seeking representations as to whether and how that can be done. But I'm not aware that any have taken place yet. Please do share your experiences if you've had any. And there doesn't appear to be any specific guidance on the point about how to carry out fact-finding hearings other than what Rowena has just said, which I think applies to the Upper Tribunal as much as it does to the first tier. What I'm going to mainly focus on is the interim arrangements specific to the IAC, which the Upper Tribunal IAC, which is set out in Presidential Guidance Note number 1 of 2020. And I'm just going to try and paste the link to that in case you haven't seen it already. There we go, that should be in the chat. And that was adopted supposedly pursuant to the Senior President of Tribunal's pilot practice direction of the 19th of March, although it is somewhat different. The IAC's guidance note was adopted without consultation and in correspondence with ILPA, as some of you will be aware. The Upper Tribunal has been somewhat resistant to the idea that we, the legal profession, might have anything useful to say about how to run things efficiently or fairly. Now, the main provisions of the note are these. It starts with the observation that, unlike some other chambers of the Upper Tribunal, the IAC does have power to make substantive decisions without a hearing, even if the parties don't agree. That is to say, in other chambers of the Tribunal, they have to have a hearing if any of the parties wants one, but that's not the case in the IAC. And the Upper Tribunal uses ovation, as it were, that it has the power to make decisions without a hearing as a kind of jumping off point for a statement that it is routinely going to use that power in cases where a hearing would previously have been held. And the guidance is limited at the moment to error of law hearings, error of law decisions, I should say, and consequent decisions on disposal. In other words, obviously, whether the decision of the first tier tribunal should be set aside for error of law. It does make the more general point that the Upper Tribunal has the power to hold hearings remotely, including by video link or by telephone, as indeed it has done from time to time in the past. Now, obviously, decisions on permission to appeal will continue to be made almost invariably without a hearing, as they have done up to now. Not entirely clear whether those are being made. Again, please let us know if you know one way or the other. But where permission to appeal has been granted, what then is supposed to happen is that an Upper Tribunal judge reviews the case on the papers, reaches what's called a provisional view on whether a decision on error of law and or setting aside can be taken without a hearing on the papers. And the Upper Tribunal judge does that, it seems, without having checked whether the appeal is actually opposed by the respondent in the Upper Tribunal, that is to say, by the successful party in the first tier tribunal. And not the least surprising aspect of the guidance, one might think, is that it drives a coach and horses through the Rule 24 process. That's obviously the process under which the respondent in the Upper Tribunal is supposed to indicate whether it opposes a finding of error of law on the part of the first tier tribunal. Now, you might think that if you were trying to streamline the process and avoid unnecessary hearings, the first thing you would do would be to actually check which appeals are unopposed and which ones can therefore go ahead on the nod, as it were. But that isn't what the tribunal has decided to do. The criteria by which the Upper Tribunal judge will decide whether to hold an error of law hearing aren't set out exhaustively, but there are two sets of circumstances in which a hearing might be necessary, at least according to paragraph 14 of the guidance note. And the first is where oral evidence or findings of fact are required. And that must mean oral evidence or findings of fact relating to what happened before the first tier tribunal. So that could be if there was some procedural irregularity, if there was some misbehaviour by the judge, and the Upper Tribunal is being asked to decide whether that's the case. Now, again, you might think that the obvious thing to do in those circumstances would be to find out whether the other side agrees that that's what happened. In other words, ask for submissions on whether the allegation of an error of law is opposed. But again, that's not the path they've gone down. The second circumstance in which the Upper Tribunal has identified for when a hearing might be required is when what it calls particularly complex, novel, or important issues of law arise. It also says that the Upper Tribunal will have regard to whether a person is legally represented, but that an unrepresented person won't necessarily be assumed to need a hearing, and it claims that some appellants may find it easier to make submissions in writing, something which you might or might not agree with. One thing the Upper Tribunal expressly won't have regard to is that the case is important to those involved. Now, that apparently isn't a reason why people might want to have a hearing, and we'll return to that point shortly, if I may. Now, in the examples that I've seen, where a provisional decision has been made on the papers that a hearing is not needed, no reasons have been given. So it simply repeats what's said in the guidance note, that the judge has reached a provisional view that a hearing is not necessary. So it isn't clear exactly which of the relevant criteria have been considered to apply or not to apply, as the case may be, and why not. If the Upper Tribunal judge decides on the basis of those criteria or for any other reason that it can't determine the error of law point without a hearing, then it will obviously list the matter for a hearing. That's obviously going to be a video link or telephone hearing, which is said to be the default. So it doesn't rule out face-to-face hearings, although it's quite hard, obviously, to see how those could be justified at this point or safely carried out. But we're assuming that these will be remote hearings. The exact form of the remote hearing, whether it's done by video or by phone or whatever, seems to be entirely at the discretion of the Upper Tribunal, which says it will inform the parties in writing of the decision and require them to give contact details. And the latest understanding that we have, I think, is that the presenting officer's unit doesn't have video link facilities. So it's not entirely clear how that will work. Again, if anybody's got any update on that, we'd be pleased to know. The guidance note then goes on to say that in any remote hearing, the principle of open justice must continue to be respected, which is nice, although of course that's a principle which it's just discarded in favour of having no hearing at all in most cases. Again, we'll come back to that. There is scope to object, I should add, in terms of, or to make representations, I should say, in terms of the form of the remote hearing, i.e. whether you think it should be better carried out by video or by phone. The intention is that remote hearings will be listed at different times rather than all at 10 a.m. So the Upper Tribunal is at least caught up with pretty much all other courts in the entire galaxy in terms of having staggered listings rather than everybody turning up at the same time. And the proceedings, we're told, will be recorded by the tribunal. They can't, of course, be recorded by the parties. Now the Upper Tribunal judge decides on a provisional basis that a hearing is not needed, then the parties are to be informed of that fact and they're to be invited to make submissions on two things. One, whether they consider that a hearing is needed, despite that provisional view, and two, at the same time, whether there was an error of law, and if so, whether the first tier decision should be set aside. And those are done sequentially, so the person seeking to demonstrate an error of law goes first, then the other side, then the appellant goes last again. Now, there are obviously a number of problems with this. First of all, if you do want a hearing, you're pushing against a partially closed door because the tribunal has already decided, at least provisionally, that you don't need one. You don't know why the hearing, why you don't need a hearing in the view of the Upper Tribunal, so you can't respond to the reasons. You don't know, at least you don't know initially, whether your appeal is opposed by the other side. And you don't know what your substantive submission should be directed at, given that it's quite likely that you've set out in your original grounds of appeal why you think there was an error of law. So you don't know what else you're expected to add to that in your submissions. And of course, just to go back one or two steps, this is a process which the Upper Tribunal thinks an unrepresented appellant can negotiate better than an oral hearing. It's also not clear, as far as I know, whether the judge who decided provisionally that you don't need an oral hearing will be the same one who makes the final decision on having a hearing, or the one who makes the substantive error of law decision. Now, the Upper Tribunal's apparent intention to abandon oral hearings is a somewhat problematic one for a number of reasons. And I've explored this on a blog post on our website, which I will try and post a link to. Those of you who may already have looked at this, I apologize because I'm about to repeat at least some of what I said in it. We exist essentially in a legal system which prizes oral argument. It prizes the process of literally appearing before a court or tribunal. And there are quite a number of reasons why oral hearings are important, even where evidence even where evidence doesn't require to be heard. Sorry, I'm just pasting the link. There we go. Hopefully you can all see that. Now, first of all, they're likely to lead to better decisions being made. Oral submissions, we all know this, are often much more persuasive than written ones. And that's why in almost all cases, you have a right of oral renewal to a court. Less so these days than you used to, but that's why we used to have oral permission hearings in the Court of Appeal. That's why we regretted their loss. That's why you have oral permission hearings in JRs, for example. And one of the main reasons why oral submissions are more persuasive than written ones is that there can be a kind of interaction between the court and the advocate. So the judge can make clear, implicitly or explicitly, what their concerns are about the case, what they do or don't find compelling in the reasons, in the arguments being advanced. And the advocate, of course, can then respond to those by pushing certain arguments hard or abandoning other arguments when it becomes apparent either that the judge has made up their mind against them or that the judge is with them. And often, of course, the matters that seem important to us as advocates can be entirely different from the matters that seem important to the judge who's actually making the decision. And you aren't going to know that unless you're there in the room with the judge responding to what they say, or possibly remotely, but perhaps less so. But at least by a remote hearing, you can have this kind of two-way communication between the advocate and the judge. And it's that ability, it seems to me, for the court to test the submissions that are being made and for the advocate to tailor their submissions in real time, which helps to make oral argument persuasive and important and helpful for the court. It's not just for us, it's also helpful for them, or it's supposed to be. Also, of course, it's often possible to tell at an oral hearing if the judge has misunderstood something, misunderstood the sequence of events, misunderstood the important facts, maybe misunderstood the law, who knows, misunderstood what the authorities decide. And we've all experienced this. I mean, I'm not saying anything, I'm sure, which is not known to you all. And it's the absolute bedrock of our legal system. And this seems to be entirely thrown out of the window by the Upper Tribunal. It's quite concerning. The second reason why we need oral hearings relates to what we might call the mutual respect of the court and the litigant. And that's related to the litigant's ability to feel that they are participating in the process, and they're being treated as a human being, and they're not being just treated as a piece of paper. And now, of course, we all have respect for the court, do we not? But it's sometimes forgotten that the court is supposed to have respect for the people appearing in front of it. It's supposed to have respect for appellants. And it's far easier, and again, this is something which we've all experienced, far easier for a tribunal to dismiss an appeal if it doesn't see the appellant, or at least their representative, appearing before it. And it's harder for the appellant to feel that they have actively participated in the case and therefore been respected by the tribunal if they're dealt with on the papers. Thirdly, third reason why we need oral hearings is the importance of justice being seen to be done. And again, that's not a principle which is foreign to any of us. There's a reason why we don't normally have cases heard in private. There's a reason why we don't have them normally heard on the papers or dealt with on the papers. And the Upper Tribunal, in fact, talks in its own guidance note, as I referred to earlier on, about the need for the principle of open justice to be respected. And as I say, that's a principle which, in fact, in later parts of the guidance note, it's thrown out of the window. And it's far from easy to see how the principle of open justice is respected if there is no hearing at all. And simply publishing the final decision, of course, is not a substitute for the process of justice, the way in which that decision is reached, to be open as well as the end result being open. And as I say, I've expanded on some of those points and linked to important case law on some of these issues in my blog, which I sent you the link for. Now, the Upper Tribunal has so far been very resistant to criticism of its guidance. It doesn't, of course, follow that in individual cases it'll necessarily reach the same view of whether a hearing is needed. This is a situation where individual submissions on the way forward in individual cases may yet have an impact, and of course it may be something which the Court of Appeal will have something to say about in due course. So that's what I had to say about the Upper Tribunal. Let me hand back to Simon, who's going to deal with the Admin Court. And thank you for your questions.
Thank you very much, Alasdair. Before we go on to the Admin Court, we've got about 20 minutes left. I just want to go back to Rowena for her to address some of the questions that have been posted on the Q&A.
Thanks, Simon. So I've had a few questions through. The first was from Smita, who noted that Newport had sent she had a CMR pending, and that had been adjourned and that she should wait to hear. So it appears that she hasn't been sent the notice that others have been sent in CMR cases, which sounds a lot more sensible, because obviously it makes no sense for pending CMRs to be suddenly replaced with a requirement to send a substantive skeleton within 15 days. The other questions, there was another one that related to a case, a deport appeal, where the individual had not received the Home Office bundle and had requested an extension of time, and there'd been no response to that. And the question was, should, in those circumstances, the rep simply file a preliminary skeleton and a preliminary bundle with a supplementary one if necessary when they've seen the Home Office bundle. I would be really wary of filing and serving a preliminary skeleton and preliminary evidence when you haven't seen the case against you. I mean, it could be different if you actually had all the constituent parts of the Home Office bundle. But in those circumstances, I think you did exactly the right thing by requesting the extension. And obviously, it's difficult to chase a tribunal now because I don't know if the phone lines are working or how you're doing that, if it's just email, I think. But in the first instance, chasing the tribunal would be what I would do. In relation to another question, which was about flexibility in relation to the directions timetable, what the latest word that we have from the tribunal is the letter from Michael Clements sent to Sonia Lenigan, the legal director of ILPA. I think it's dated the 1st of April. This is available on the ILPA website. But in essence, I'll just summarise the points that he says. The first is that where there are difficulties with compliance with timescales, the directions provide for applications by either party. So again, it's that paragraph 4 of the general notice, the need to make an application, which is the first port of call. And then goes on to say, it is expected that parties will comply. So I don't think we can rely on flexibility and the tribunal turning a blind eye. So in terms of whether you comply or not, I think it's difficult not to, given that's the tribunal's stance. But clearly, of course, applying is the first thing you need to do, applying for extensions, applying for adjournments. And what the letter goes on to say is that, as is currently the case where there is a default without explanation or good cause or good reason, appeals might be decided without a hearing, but we expect this will be so in a very small number of cases. So that is the risk that you run if you don't comply. Obviously, that's kind of the worst case scenario. But again, complying with the tribunal by making applications for extensions, and in your case, the deport case where the Home Office bundle hadn't been received, it's entirely legitimate in my view there to need to see that before you can properly respond. I mean, you could perhaps just send in a holding skeleton saying, without seeing the respondent's case, we cannot properly substantively argue this case and send the evidence you have so far. Also noting that the case isn't evidentially ready. That would, in some respects, kind of preserve your position and make sure you comply with the timescales, but without giving anything away on the substantive case, because you wouldn't want the tribunal then to take that as your case and to run with it in terms of whether or not a hearing is necessary. What I would say is that the tribunal cannot stop you from putting in more evidence. So there's no provision, even under the pilot directions, to prevent you adding more evidence after that initial appeal skeleton argument. So that will always be available to you, which is obviously reassuring. What appears to be the case in relation to the online pilot, HMCTS, I don't think, are going to be allowing people to submit a new skeleton argument later, but that's slightly different because that relates to the online digital pilot, which this currently isn't, even though they're applying part of the directions to it. There was a question about deportation cases and whether they're going to be put on hold. In relation to that, I'll just again refer you back to the letter from Michael Clements. So what he says is that he's taken the decision to vacate lists, take stock, establish a sound footing for case management to meet the impact of the pandemic. I'm just reading the letter here. Triage cases where we can, and then list those cases to be decided by means of a remote hearing, with those not suitable being adjourned for a time when face-to-face hearings again become possible. So for the person who wrote in about the complex deport case, lots of witnesses, etc., I think that is most likely to be the case, that this will be adjourned off until we can have face-to-face hearings again. Oh, and one more point. So I think Alasdair mentioned the POs not having any video conferencing facilities at the moment. As I understand it, that is going to be remedied relatively soon, and they're trialling, HMCTS are trialling with the Home Office to video conferencing software in order to enable them to partake in video remote hearings rather than just telephone. But again, there's no time frame for that, although you'd hope it was urgent. So I think that's all I had to say on the questions that have come through before. I see there's a few more.
Rowena, why don't I, while you have a think about those, I just want to go over to Alasdair.
Just very briefly, I just wanted to say I think it's really important that we don't work on the basis that these directions, which are sent out on a very generic basis, are the last word in our cases. It's really important to write into the tribunal and say, this is what my case is about, this is what we need, these are the directions we want case-specific directions, and we don't want generic directions which have nothing to do with us. That's what I've advised in a number of the cases which are ongoing. I think one or two of you are on this call have had those discussions with me, but it's really, really important not to think that these are set in stone. These are not procedure rules. They are directions which are supposed to be fact sensitive. And if they're not, then you do have the right to write in and ask for them to be amended. That's not to say, of course, you should not comply with them until they have been amended, or at least until you've made the application for them to be amended.
Thank you. That's great. So I wanted to just quickly cover some of the latest developments in the administrative court, and then we'll go back to Rowena and Alasdair for any more answers to your questions. If you've got a general comment that you're happy for everybody to see, please just post it to all in the chat. If you've got questions that you want answered by the panel, either post them in the chat or post them in the Q&A to me, and I'll pick them up and pass them on to the panel. So I wanted to pick up two of the things that we've seen happening in the administrative court in the last 3 weeks. The first of those is the move to e-filing, and the second of those is remote hearings. Now, when it comes to e-filing, we're seeing this most acutely in what the court is now calling immediates, in which the court is expecting to have an immediate application bundle. And so these have been cases where people are seeking release from detention, they're seeking asylum support, and who knows, it may be that if the Home Office resumes removals, that they'll be dealt with for removal hearings. And I'd be interested to know whether or not anybody's had any attempted removals in the last couple of weeks since the government announced the stay-at-home policy. The The e-filing system, as I say, requires a single PDF bundle, and that is both, I think, an occasion for us to have to do a lot more work up front, particularly solicitors, but also I think it's an opportunity to rationalize and simplify some of the ways that we already do our work. Right now, it's only being required for urgent matters, this idea of a single bundle, but my guess is that, like remote hearings, that these will eventually, I think by the end of this crisis, will have become the norm or the default position. I think judges will get to like the idea of having a series of single PDFs that are bookmarked, are indexed, are formatted in a way that means they can be cut and pasted with text going straight into judgments. And I think for very understandable reasons, it's going to be hard to go back to days of judges having lever arch files only, though they may well end up with both of them. So just a few highlights really about the way that the new single PDFs work. First of all, the court is expecting them to be quite small with a maximum of 20 megabytes, which is one of the reasons why it's important to keep the documents in them to a minimum, to make sure that you've deleted any blank pages or any surplus pages towards the end of emails. And also because if you're a judge who, like me, is working on a iPad, then you're scrolling with your finger and you don't want to have to scroll past dozens of pages. You'll also need to bookmark the documents so that people can go very quickly to the individual documents that are being used. The PDF pages have to be optimized so that where there is recognizable text in a document that was originally a PDF or a Word document, the text can be cut and pasted. So there's significant work up front, but I certainly think it's worthwhile firms investing now in learning how to do that, in identifying people within the firm who are going to be good at doing that. In chambers, we've already had our junior clerks who work as the office assistants, who are really building their expertise in learning how to create these PDFs, because we know that we're going to have to be creating them for authorities bundles and other documents that counsel are expected to file with the courts. But also I do think it's a potential way for us all to be able to work faster and to be more flexible. Certainly as counsel, I've had the benefit of having some really excellent PDF bundles, and getting a single bundle with all of the documents that I know I need to read with an index down the side means that I can work on that anywhere and I can work on it much more quickly. Secondly, then, talking about remote hearings, I'm going to run through some tips in a moment, but I think the most important tip is that if you haven't already done a remote hearing, if you are an advocate, and in particular, if you're going to be working as part of a team, so if you are in a hearing where you would be solicitor sitting with counsel or behind counsel in the High Court, or if you're an advocate who would be appearing in a hearing with their client, where they would want to take instructions from their client during the hearing, as you might at a first-tier tribunal or an upper tribunal hearing where points are made, and certainly in an administrative court hearing, then I think there's no real substitute for actually practicing that. Get a colleague to pretend to be the judge, or get a colleague to pretend to be your opponent. Use Skype for Business, because only then will you really pick up on all the little wrinkles that might really throw you as an advocate if you're doing a hearing. So a few of those tips then. First of all, before you're going to do the hearing, schedule conferences online with your legal colleagues, with your clients. Make sure you know what platform you're going to use and what time that meeting is going to take place, and ideally arrange that the person who's going to host that call isn't the person who's going to be the most busiest at that time. So if you're doing a hearing, a judicial review hearing, don't expect counsel or leading counsel to be the person who's arranging that call. Make it somebody else, and make sure that the details are circulated well in advance. You're going to want to be able to take instructions from your client during the hearing, and that's true for a first-tier tribunal and an upper tribunal. You may get points being made in submissions by the Home Office. You're going to want to have a means of hearing from your client what they say about those submissions. So set up a WhatsApp group with your clients, set up a series of WhatsApp groups if you're in a trial in the High Court, so that you've got one for solicitor, counsel, leading counsel, and you've got another one for the client and then selected counsel. Perhaps don't put your leading counsel in that second WhatsApp group, because in the middle of their submissions to the Court of Appeal, they don't necessarily want to have pinging up from the client, the concerns of the client. Think about how you would do it at a normal hearing, with post-it notes or messages being passed forward to counsel, and then try and arrange a WhatsApp group that way. Make sure you label the WhatsApp groups really clearly, so that you don't accidentally send a message about the client to the client, or about your leading counsel to your leading counsel, if that isn't a message that you wanted them to receive. Start early for any hearing. Don't take the tech for granted. Assume that there will be teething problems with the tech. Make sure that your client, your counsel, your solicitor are online 10 minutes before the hearing. Make sure that your client and your counsel have a private space in which they can take the hearing. It isn't one where the dog is suddenly going to burst in behind the client. It isn't one where the children are going to come running in, or the postman's going to knock on the door. And that's particularly so if it is actually a hearing in private, one that would be closed normally because it's concerning a particularly sensitive matter about your client. Judges will rightly be concerned if they're holding what is supposed to be a confidential hearing and suddenly the door behind you opens and it's your partner or your children coming into the room. Plan for losing your advocate. Assume that at some point during your hearing, your advocate's Wi-Fi or computer is going to go bust. What's going to happen for the minutes that it takes for that person to come back in? Who is going to take over? Who is going to communicate to your advocate that nobody else can hear them? And how are they going to be aware of that while they're talking in full flow, that in fact they've lost contact or their mic is broken? So have a mechanism that's going to be able to communicate with them. If you are the advocate, I think it's very hard to do this without multiple screens. It's very hard to be looking at the bundle on the screen and talking into the screen or into the camera above the screen at the same time. Close off your other applications, close off all the documents that you don't need on any of the screens that you have. Open your e-bundles, download them before you start the hearing, because they're going to take up a lot of bandwidth and you don't want them slowing down the connection. As I said, not only check that your door is closed and you're in private, but check that your camera is pointing at something appropriate and that your backdrop behind you is something appropriate. If you need to hang a sheet over your bookshelf or over your artwork or whatever it is that you have behind you, if you don't want it to be distracting anybody. If you can, make sure your camera is on a solid basis. If you have it on your lap, it's going to do that while you're talking, which somebody else on the call is bound to find distracting. Remember, and Zoom calls are a good experience for this, your head suddenly looms very large in the room. It's a little bit like you're talking to the judge from 6 inches away. So everything about your face, whether there's a bit of lunch left on it or whether there's a smear on your glasses, and certainly if you're playing with your face, poking at your face, scratching your face, all of those things become very distracting for the judge. And if you're on video while your opponent's talking, if you're doing that, if you're doing that, if you're doing that, if you're doing that, all of those are going to be seen by the judge. So only do that if you want the judge to see you doing that. Have your cup of coffee by the screen. Have your snacks by the screen. You may not feel that you can leave the screen, so make sure that you have everything that you need right by you. But as I said at the beginning, trial it out. Okay, we've got a couple of minutes left. I'm just going to quickly post a couple of the queries that I saw. I'm going to post yours, Monica, but back over to you, Rowena, for the last few minutes to answer the questions that we have.
Yes, so first one in the list was from Nigel Leskin. asking about what the problem is with funding where a case is likely to meet the a threshold for being an escape fee case. We had a discussion about this in Chambers, and where it's an escape fee case, or very likely to be one, we can't see that there's a problem with the funding gap there, because it's hourly rates, so it will be hourly rates in any event. If it's a borderline case and you're not sure if it's going to be escape fee or not, then obviously it would still be at risk. But as I understand it, it's the problem is about the fixed fee, and it wouldn't apply in escape fee cases. There's been several people posting about the difficulties of taking a statement remotely, and I hope I reposted the point that someone made about a best practice in taking instructions, something that someone posted on Twitter. And I entirely concur. And of course, you are most the experts on this, really, because I don't generally take witness statements. But I do understand the concerns there, especially in cases, the same concerns really that apply in relation to people giving evidence from homes in cases where victims of trafficking, very vulnerable people with mental health difficulties, domestic violence victims. I can see all sorts of problems, not knowing whether there is someone else in the room when you're taking instructions. That also applies, the same problems apply there as to when somebody will be giving evidence from home. So I think there are real problems in relation to taking instructions and being able to provide witness statements and provide evidence. And I think the answer probably then comes down to what Alasdair and Tori also in the comments were saying, and that you need to then communicate with the tribunal what these difficulties are and give as much detail as possible. And at least Tori said that from her experience, the tribunal has been understanding of the need for extensions, etc., in cases where there's been the need for reports, as long as you give as much detail as possible and explain the position. And I think that has to be the way forwards. And as Alasdair said, ask for case-specific directions tailored to the needs of your case. In relation to, I think that there's a couple more, but I haven't actually read yet. I don't know if anyone else is able to pick up on those. There are a couple of questions from someone else. The first question is, if a deportation pre-hearing review has been adjourned and a new date is going to be provided, would it be sensible to provide all evidence prior to the new date, even if the respondent hadn't served her own bundle? Well, I think then it would really depend on what you get sent out. I don't know if you've been sent out the notice or the directions, but don't feel the need to do anything until you get a direction or any kind of notice for the new hearing. So I'd hold off there. If it's a case that you're not able to do that, and indeed I would suggest that without having seen the respondent's bundle, you shouldn't be providing your bundle yet, then it would be a case of, again, proactively writing to the tribunal and setting out what you need before you can do anything. Second question, can the judge decide a deportation case without asking for more documents from both parties? I'm not entirely sure what that's getting to, whether that means a hearing on the papers. I discussed that in some detail in the presentation, so you can go back to the recording of that. But otherwise, I don't think that that could be the case.
So I think, Rowena,
yeah.
No, that's great. Thank you so much. So for everybody who joined the call, thank you very much. This was actually our first stab at a Zoom seminar. It's part of a series of rapid responses that we're trying to do to the most pressing issues that as immigration practitioners we're facing. So we'll respond to the outstanding questions in the chat or by email. But for now, I'd just like to say thank you all very much for coming. Please do send us emails if there are other topics that you'd like to have these kinds of Zoom seminars on when we can hold them and make sure that everybody hears what everybody else is experiencing and some of the ways that we're trialing of responding to these very difficult situations. So I hope everybody and all your families and friends stays well. and we will see you all again online soon. Thank you very much.